Welcome back to the Law and Crime Network. I'm Heather Hansen, and we're continuing to cover the second murder trial of Jeffrey Willis, who is accused of killing Jessica Haringa. Her body has not been found. And so we have been listening to some of the testimony of a woman, a young girl who at 16 years old was abducted by Jeffrey Willis and was able to get away. I have with me my guest, Nicole DeBorde. Nicole is a former prosecutor, current defense attorney, fabulous person to give us some insight into what exactly is going on with this very complicated case. Welcome, Nicole.
Thanks for having me.
Oh, it's wonderful to have you. I wanted to ask you, because one of the things I've seen many people question in this case is why would it be that the prosecutors would pursue this case when in a situation where he has already been convicted of murder in another case? Can you explain that to our audience?
Well, a lot of times prosecutors want to convict a person in an additional case if another case is going to go up on appeal, or if they may have parole rights on the case that there's an earlier conviction on. Sometimes they just want to make sure that they represent each of the victims in a particular series of crimes. So there's a multitude of reasons they may decide to proceed even when a very tough sentence has been handed out on a previous case.
And the victim in this case, given the fact that her body is missing, her mother, Shelley Haringa, has actually refused to believe that her daughter has actually died. Now, in a situation like that, Nicole, when you were a prosecutor, would that be a witness that you would then not call because you don't want to have this one element of doubt part of the case? Or do you still call her and just argue to the jury that this is a grieving mother who's unwilling to accept that the possibility that such horrendous crimes had been done against her daughter?
It really depends on whether or not they need her. It's a really tough thing, as I'm sure everyone can imagine, calling a family member of someone who has disappeared or is thought to have been killed to the stand in a trial about that very person. And sometimes it's necessary to call them to identify things or places, or even, unfortunately, sometimes the body. Right. If it's not necessary to do it, it's probably not a great idea to do it. Jurors pick up on that when you call a witness who is really suffering, right, put them on the stand unnecessarily, and it can anger jurors.
Right. Well, we will see whether or not that witness gets called. Right now, we're going to take you to a quick break, and we'll be back in just a minute. Welcome back to the Law and Crime Network. I'm Heather Hansen, and we have been covering the second murder trial of Jeffrey Willis. He is now accused of murdering Jessica Haringa. Her body has never been found. However, we do know that there are numerous pieces of circumstantial evidence that tie Jeffrey Willis to this case. Specifically, the computer evidence was a file that was labeled Victims, or VICS, that included Jessica Haringa as one of the people noted in that file. We're going to be continuing with clips of that case today, but in the meantime, we also wanted to show you a little bit about the next case that we're going to be covering. This is the case of Wisconsin versus Philip Holland. It is a case that involves drugs, an allegation of self-defense, and murder with multiple strikes to the head. Watch this little intro to that case with us, and we'll discuss. And that's going to be quite the interesting case, the case against Philip Holland and his male ego not allowing him to walk away from a fight, wondering whether or not that will actually fly if he tries to take the position that it was actually done in self-defense. Going to be an interesting argument, Nicole. In just a minute, I want to talk to you about that. But first, I want our listeners to hear a little bit about the top legal stories of the day.
Here are today's top crime stories trending on lawandcrime.com and across the country. A police detective in Kentucky is accused of offering a ride home to a rape victim, but instead took her to a motel and demanded sex. Detective John W. Neeson of the Hillview Police Department is charged with theft by deception, tampering with a witness, and official misconduct. He reportedly offered to drive the victim home, but instead drove her to the home of her alleged rapist, where he and the perpetrator pooled money together so the woman could purchase a phone. That's when the victim claims Neeson took her to a motel room and reportedly demanded oral sex. Neeson has not entered a plea and is currently suspended from service. A former mafia boss who led the New England family of La Cosa Nostra in the early 1990s is charged with the 1993 murder of a nightclub owner. Francis Cadillac Frank Salemme is accused of killing Steve DeSaro to prevent him from cooperating with authorities. DeSaro's nightclub, The Channel, was being investigated by federal authorities for Salemme's involvement in the business before he disappeared. His body was discovered in 2016 after authorities received a tip. Salemme's attorney admits his client is no angel, but adamantly denies his client having any involvement in DeSaro's death. Salemme was charged with participating in 8 murders in 1995 and pleaded guilty in 1999 to racketeering and extortion. The high-profile murder trial will resume today. A crazy melee unfolded in a Florida courtroom after a guilty verdict was read in a murder trial. Video shows the eruption of violence after the verdict was delivered in a murder trial with 4 defendants. 3 of the co-defendants can be seen brawling with their own defense attorneys and court bailiffs. Once order was restored to the court, all 4 defendants were sentenced to life in prison. The 4 men were convicted in the shooting death of 28-year-old Courtney London in 2016. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Welcome back to the Law and Crime Network. I'm Heather Hansen, and with me is Nicole DeBorde, who has insight as both a former prosecutor and a current defense attorney. Nicole, I want to talk to you about the testimony of this witness, Madison Nygaard, the girl who was just 16 years old when she was abducted by Jeffrey Willis and was able to actually escape. And many say it's her testimony and her going to the police and her willingness to be as strong as she was that allowed the police to find enough evidence to bring charges against Jeffrey Willis for both the allegations against him in this case, the case of the disappearance and murder of Jessica Herringa, but also the case he's already been convicted of, the case of the murder of Rebecca Blesh. What do you think about this witness's testimony and how it must impact a jury?
I think it's just brutal for the defense. This is a person who can speak in a very organized and linear way about what happened to her. The calmness with which she tells this horrific story is chilling, and I think this is going to be a very, very difficult hurdle for the defense to overcome.
Yeah, there's been a lot of talk at the Law and Crime Network and throughout legal circles about whether or not it was appropriate for the judge to allow this type of testimony in. There, oftentimes we hear this type of testimony does not get in because it's not relevant and it's prejudicial. And so in this situation, it reminds me of the Bill Cosby case in that evidence of other acts were actually allowed in. Do you think the judge made the right call, and why or why not?
I think it's tough to say. It is absolutely relevant because it is one of these circumstances where the modus operandi, or the way that the crime was committed, seems to link this crime to the crime that he's actually on trial for. Now, the real risk in doing this, when you have such circumstantial evidence on the primary case, which is exactly what is the situation here, is that the jurors could convict the person on trial for something else. In other words, he's on trial for one crime. They're hearing their best evidence about another crime, and that very strong evidence is very likely to anger this jury. And we will never know whether or not these jurors actually convicted this defendant because of the evidence in this case, or because they were mad at this defendant for this horrific information that they're receiving about a completely different case altogether.
Well, in this case, there's so much horrific evidence. I mean, we've heard about the files on the computer and the really disturbing images that this defendant had on the computer, and then all of the sex toys that he had and that he was into, and the different types of pornography that he had on his computer, and all of those things together, Nicole, isn't it really difficult for the defense to climb out from one of these allegations? But if you add them all up, how much do you think the defense actually has a chance with all of the different things that are coming in against Jeffrey Willis?
I think their chance is very small, and I think this particular witness's testimony has decreased that very small chance even further. And that's the real risk of letting evidence like this in. We really need to be able to depend on the idea that every single trial is about the accusation. And when you start clouding it with horrific testimony about unrelated cases, I say unrelated, but it's not this case. It wasn't anything in her testimony that was leading up to what happened or what they say happened in this case. So it's a tough situation, and I, for that reason, feel like the judge probably should not have let this information in.
And I think that you might be right, but he actually did let that information in. And let's go back and listen to some more of this. Now, remember, this is testimony of the young girl, 16 years old at the time, who was abducted by the defendant, Jeffrey Willis. She was able to get away, and now she's here testifying against the jury that has to decide Jeffrey Willis's fate with regard to the allegations of murder of Jessica Herring. So we're going to take you back to that young girl's testimony. Welcome back to the Law and Crime Network, where we are continuing to cover the murder trial of Jeffrey Willis. Now, remember, ladies and gentlemen, this is his second murder trial. He has been convicted of the murder of Rebecca Blesh. That case is already done. That jury found him guilty. He is now on trial for the murder of Jessica Herring. The issue with this case is that her body has never been found, and without a body, oftentimes these cases are more difficult to prove. The person who was just testifying that you've been listening to for the past few minutes is the young girl, 16 years old at the time, who was abducted by Jeffrey Willis and may have found herself in the same fate had she not been able to escape. You just heard at the very end of her testimony she was able to identify Jeffrey Willis. What a strong young woman. I have with me Nicole DeBorde. She is a former prosecutor, a current defense attorney. She knows it all, and she's here to share it all with us. Nicole, thank you so much for being here with us. You know, that testimony, as you said, is especially gripping because she's such a young lady. Witnesses like that one, do they get some extra counseling, some extra preparation in order to testify, or does the prosecutor just hope that the draw of the story will be enough to carry through?
You know, it really depends on the prosecutor, and it depends on the capabilities of the witness to tell a story. And, it's hard to say just watching the testimony how much preparation actually went into this. That's going to be lawyer to lawyer, a very different preparation scenario.
Yeah, I would imagine so. And someone like this, I mean, she's been so strong, so consistently. And after having testified in the first trial, at a certain point in time, practice does make, if not perfect, then at least more comfortable. Isn't that true?
I think that's definitely true. You know, on the positive for the witness, it makes them more comfortable in the courtroom. Now, there's definitely a negative. Once you start having multiple recorded transcripts of your testimony, you can run into trouble with inconsistencies, and you can bet that the other side will have copies of whatever information it is that you've already told the court. So if you go outside of the story that you've told previously, you could find yourself at the pointy end of a pretty difficult cross-examination.
Yeah, that's very true. And in fact, at the end of most cases, the judges will actually instruct the jury that if they found that there was some inconsistencies, they can disregard all of the testimony. But do you think in this case with this victim, that's a threat at all here?
It doesn't seem like it so far. Certainly cross-examination will tell if maybe there's some detail that we're not picking up on, that she's saying something different than what she's previously testified to, or something different than what she told police or law enforcement at the time. We haven't seen that so far, so it doesn't seem to be a problem for this witness.
Now, Jessica Herring is the victim in this case, and as we've noted, her body has never been found. That's certainly a problem here. There's other potential issues for the prosecution as well. We've discussed the fact that the mother, Shelley, does not believe that her daughter has actually been murdered, and until she sees the body, she's not likely to so believe. Do you think, though, that, Nicole, that given the horrific nature of Jeffrey Willis's crimes, that it's psychologically completely understandable and that the jury will understand why a mother would not want to believe that her daughter would have been another victim of this monster?
I think absolutely. I think for the most part, you could probably expect jurors to look past that issue, unfortunately, because of the testimony of this 16-year-old. And, you know, it is possible that it could cause some jurors to have a little bit of pause or maybe even hang up on the issue, but I can't imagine that that alone will broadly create a problem for the prosecution.
The other problem for the prosecution may be in some of Jessica's past. Apparently, she had some interactions, had been doing some heroin, at least at times, according to some of the allegations and some of the questioning. And that came up in the questioning of Jessica's boyfriend. Now, remember, this is the victim who Jeffrey Willis is alleged to have murdered, her boyfriend, who we're going to watch a little bit of his testimony here in the stand. And then I want to talk to Nicole, our guest, about the implications of that testimony on the prosecution's case. But right now, we're going to be listening to the boyfriend of the victim talk a little bit about their lives and a little bit about some interactions that they had that may hurt the prosecution. Welcome back to the Law and Crime Network. I'm here with Nicole DeBorde as we continue to talk about this case of Jeffrey Willis, who is accused of the murder of Jessica Haringa. Her body never found, but the testimony continues to pile up against Jeffrey Willis. There you saw the testimony of Jessica's boyfriend, the victim's boyfriend, who was being cross-examined pretty strongly with regards to Jessica's drug use and her fights with her drug dealer and her fights with her boyfriend and her boyfriend's fights with the drug dealer. Nicole, what do you think that testimony was meant to establish, and how effective do you think it was?
You know, I'm not really sure what they were after. I'm not sure if they were trying to make it look like the victim is somehow responsible for this, maybe make it look like the victim could have been attacked by somebody else. I really don't know where they were trying to go with it, but I do know that that strategy is a very dangerous one, whatever it was they were trying to accomplish. Jurors don't like you trying to dirty up the victim for especially no particular reason. It seems pretty nebulous and just sort of mean, quite frankly, and jurors pick up on that.
Yeah, we are going to hear from a coworker shortly who, when she saw the van that we now know belonged to Jeffrey Willis, when she saw that van outside of the gas station where the victim, Jessica Haringa, was working that night, she thought perhaps that Jessica Haringa was actually robbing the store. So perhaps it is that the defense is trying to establish that Jessica had interactions with less than scrupulous characters and that those types of people could, in fact, be responsible for her death. But Nicole, I think you'd agree that that idea, that strategy would be a whole lot more effective on the defense's side if they had a less culpable and less unlikable defendant on their hands.
Sure, and more evidence that there's somebody with a real motive to do her harm, which, you know, this sort of speculative, just pointing out that she maybe had a drug habit, that she'd stolen things before, sort of implies that they just don't want the jurors to care about the victim, and that doesn't generally work.
Yeah, it's certainly, attacking the victim is always dangerous, but especially in a situation like this when you have such an unlikable and, in fact, many would say disgusting client on your hands. But it does leave the defense with very little to do. You know, they are sort of, their hands are tied in so many ways. This evidence has now gotten in. They're attempting to point the finger anywhere that they can. If you're defending this case, Nicole, is there anything that you can think to do to save Jeffrey Willis on this particular charge?
I think that they should be just harping on the idea that this case is entirely circumstantial. There's not a body. There's not any direct evidence that a crime was even committed here, that he committed the crime. We don't know enough about this particular case to know that he's responsible, and they should stick to the evidence in this case and disregard anything else that they're hearing about other bad behavior. That's what I think the defense attorney could have some success with.
Yeah, it's certainly, circumstantial evidence is still evidence, but it certainly is not a lot to tie this defendant to this crime. One of the pieces of evidence that the jury has heard quite a bit about and from is Jeffrey Willis's ex-wife, Charlene Bishop. And in just a minute, we're going to play a little bit of her testimony. But again, Nicole, she's another example of a whole lot of circumstantial evidence, but nothing concrete, no concrete piece of DNA, no concrete piece of evidence, nothing concrete to link Jeffrey Willis to the murder of Jessica Haringa. Do you think that that is going to be a big part of the defense's case when it gets to be their turn?
It should be. Not liking this guy is really not enough to decide that he's guilty of this crime. And it seems like the prosecution is working really hard to make sure that this jury just doesn't like the defendant. And anything the defense can do to separate not liking a guy from the actual work and law enforcement case that they're presenting has got to be done by this defense team.
In just a minute, we're going to come back and play some clips from Charlene Bishop, the ex-wife of the defendant in this case, Jeffrey Willis. But for right now, we're going to take a quick break, and we'll be right back. Welcome back to the Law and Crime Network, where we continue to cover the murder trial of Jeffrey Willis. Jeffrey Willis is accused of killing, in this case, accused of killing Jessica Herringa. Her body never found, but many pieces, as Nicole DeBorde, our guest, has pointed out, of circumstantial evidence tying Jeffrey Willis to this crime. He has already been convicted of the murder of Rebecca Blesh. He also is accused of the abduction of the key witness in both cases, and that's Madison Nygaard. And, you know, it's interesting, Nicole, all of these pieces of evidence, as you said, they're all circumstantial evidence. But when you build one upon the other, circumstantial evidence is certainly enough to convict, isn't it?
And the law says that you can use circumstantial evidence. Really, there's not always going to be direct evidence. You're not going to always see that a defendant has committed a crime in front of a witness. You're not going to have a video camera, and you're not going to have DNA. But a person can still be found guilty of a crime. So in those circumstances, it's the defense's job to make sure they've gone over every single piece of evidence that seems to point to their client, to make sure they understand all the angles and make sure the jury understands them at trial.
Yeah, and that piece about DNA evidence, I find that juries today, because of Law and Crime and all of those types, CSI, all of those types of shows where juries, people are sitting at home seeing all of this DNA evidence just sitting around waiting to be discovered. Do you think that jurors expect more direct evidence these days than they used to because they see so much about DNA out there?
I think so, and I think jurors are smart. You know, they are willing to look through the prosecution's case when the prosecution's trying to prop some, you know, faulty science up and make jurors believe that it's something like evidence. And so the defense has to do a good job of pointing out to the jurors when science isn't science at all. So, you know, jurors expect to see some hard work to make sure that if there's scientific evidence out there, they're going to see it. But if there's not, they need to understand why law enforcement either didn't collect it or why it wasn't available.
It's interesting that oftentimes circumstantial evidence is an easier story to tell. As in this case, we've got Jeffrey Willis. He was at one point married to this woman, Charlene Bishop. And Charlene Bishop was called as a witness in this murder case against Jeffrey Willis. And she's testified about some inconsistencies about their lives, a whole lot of testimony about things that he was doing with regards to having videotaped girls at swim meets, having a number of inappropriate, to say the least, information on his computer. This type of circumstantial evidence certainly tells a compelling story. Nicole, how does it work to overcome a story that compelling?
You know, that's a really tough problem. I mean, this is certainly evidence that we would call inflammatory, and a judge has to be careful about letting in evidence that's, or information, testimony, that's more inflammatory than it is valuable to finding out the truth, finding out, you know, whether or not the person is guilty of a crime. So this is particularly inflammatory evidence, and this jury is hearing it. I'm not sure there's a whole lot this defense team is going to be able to do to overcome it, other than to point out that it's not evidence of a crime in this case. This is just designed to get the jurors mad at the defendant. Don't fall victim to it, should be what the defense team is saying to this jury.
Well, let's listen to that evidence. This is the testimony of the ex-wife of Jeffrey Willis and see just how mad it might make the jury, and then we'll come back and discuss it. Welcome back to the Law and Crime Network. I'm Heather Hansen here with Nicole DeBorde, and we're talking about the testimony of Jeffrey Willis's ex-wife. Jeffrey Willis accused of the murder of Jessica Herringa, and the ex-wife talking about some things that in some ways may seem disjointed, but there is a method to the prosecutor's madness. So let's break some of those things down, Nicole. First of all, there's some testimony and some questioning about her insulin use. Now, we know that the ex-wife of the defendant was an insulin-dependent diabetic, but she used a pump. And the reason that the prosecutor is asking about that is because syringes were found in the materials that Jeffrey Willis had. How harmful is that particular testimony to the defense in this case?
I think it's harmful because the defense is trying to at least put plausible reasons for having some of this material out to the jury. And she's basically saying, I don't need those needles. So this was not for me. You know, one of the things that I noted too early in her testimony is there's some extra stuff coming in, the stuff that they're using to try to kind of poke at this jury and make them mad. The comment by this witness, which was elicited for sure on purpose by the prosecution, was, does he go to church with you much? Oh, he doesn't like to go to church. This isn't evidence that is probative in any way, but it is definitely information that is probably going to bother some of these jurors.
It's an interesting point, Nicole, because as attorneys, whether you're on the defense side or the prosecution side, there's things that you can object to and you choose not to because you anticipate your objection will be denied and you don't want to look like you're losing in front of the jury, or you don't want to look like you're hiding something from the jury. Do you think that that was a situation? Because I heard that as well. That was a question, that what's the relevance of whether or not he went to church. Do you think that the defense attorney made a conscious decision not to object because they've already lost on a lot of similar issues, and to lose that objection in front of the jury is just one more nail in the coffin?
It's definitely possible, and the genie was already out of the bottle in this particular circumstance, so objecting to it may have preserved some error potentially. If they're going to later write in an appeal about the idea that the prosecution was really just going down this very inflammatory road without real purpose other than to make the jury mad. On the other hand, this is something potentially, if the defense knew it was coming, that could have been addressed in what we call a motion in limine before trial. Say, hey, judge, we know that this information might potentially come out of this witness, and we don't want it to. So we want a ruling now on whether or not this kind of evidence would be admissible. And that might help prevent it moving forward.
Yeah, we know that there were a lot of motion in limines, or motions to preclude a lot of evidence in this case, and there were rulings for both sides. There were some things that the judge did rule were too prejudicial, too inflammatory to let into the case, but for the most part, he did allow in a lot of what we've talked about here with Nicole today. The evidence about the other crimes, the evidence about the abduction, a lot of things that the defense would have hoped to have kept out. The other piece of Charlene Bishop's testimony that I wanted to ask you about, Nicole, is this testimony with regards to the fact that he has a daughter, but no one who goes to swim meets. And later on, we're going to hear from a computer expert that there wasn't just one or two or three pieces of video of girls at swim meets, but something like 15,000 pieces of video in Jeffrey Willis's computer files of girls at swim meets. Again, how much bearing does that have on this particular case, and how much bearing does it have on the entire picture of what we're talking about here of inflammatory evidence against Jeffrey Willis?
Well, I think that you raise a very good point. And this witness testified not only that the tower of the computer was her ex-husband's computer, that is relevant potentially to the prosecution's case, but thousands of images of girls at swim meets that have nothing to do with this particular victim really doesn't have much to do with whether or not he's guilty of this particular crime, and certainly seems designed to inflame the jury and make them mad.
Yeah, and I think that there are plenty of our viewers, plenty of our listeners at Sirius, they are inflamed. And they are thinking, you know what, let it all in because this guy is guilty. And that's definitely something that, if we look at our listeners, we look at our viewers as potential jurors, it is definitely something that you see in cases like this where juries are bound to grasp onto some of these horrific issues, these horrific images, and allow them to sway them, don't they?
I agree. I mean, the reality is that I'm hearing this information and I'm mad about it. I certainly don't like this defendant from just hearing the information that I've heard. But, I have to ask myself, when we look at how our court system works, do we want to convict people based on all kinds of other evidence that has nothing to do with whatever was collected to prove that he was guilty in this case? Or do we want to convict them based on just their personality and sort of grossness in general? And I think the answer is we only want to do it if there's evidence in the case in question. Yeah,
and we're going to watch a little bit more evidence, and a little, this is going to be sort of a repetitive theme here with Nicole and I, some of the evidence that is getting in, and this evidence particularly from Jeffrey Willis's ex-wife. So let's listen to some more of her testimony and come back and discuss the specifics of that testimony as well. Welcome back to the Law and Crime Network, where we continue to cover the murder trial of Jeffrey Willis. And I have with me Nicole DeBorde. And Nicole, I want to very briefly talk to you about that during the time that the ex-wife of the defendant was testifying about her dogs, she referred to them as my babies. And the camera happened to catch Jeffrey Willis laughing at that and sort of, in my opinion, making fun of his ex-wife for referring to her dogs as babies. Very important for defendants to remember that they are always on camera when it comes to the juries, isn't it?
Oh, most definitely. And any lawyer that does jury trial work will tell you, you are on the hot seat from the minute you get in your car to head to court for trial until the minute you hit your front door. You don't know if that person that cut you off in traffic, make an ugly gesture to, is be that person on your jury. So the things that you do and the things that you make faces about and your body language is all something a jury can see, and the lawyers need to be careful about it, and most definitely the accused needs to be careful about it.
Yeah, it definitely changes the way that some people live their days, and in many ways we would be well served by living our lives as if everyone around us is a juror ready to decide our fate. For right now, though, I do want to go back to the continued testimony of Charlene Bishop as she continues to talk about some of the ins and outs of their marriage and their lifestyle, and some pieces of evidence that are going to be very important to this jury. So we're going to throw to another clip of Charlene, and Nicole and I will be back. Welcome back to the Law and Crime Network. I'm Heather Hansen here with Nicole DeBorde as we continue to talk about this case against Jeffrey Willis. Jeffrey Willis, who is accused of the murder of Jessica Haringa. Jessica Haringa's body has never been found, and that's one of the many reasons that the prosecutors would arguably have an uphill climb in meeting their burden in this case. Her body never found, no real direct evidence tying Jeffrey Willis to this murder, and yet the evidence of the other murders, the murder of Rebecca Blash, which Jeffrey Willis has already been convicted of, have gotten in. And the fact that that evidence has gotten in certainly makes this case difficult for the defense. When we come back, Nicole and I will discuss all of that. But in the meantime, we're going to take you to a quick break. Welcome back to the Law and Crime Network. I'm here with Nicole DeBorde as we continue to pick apart the testimony of Charlene Bishop. Charlene, the ex-wife of the defendant Jeffrey Willis. And, you know, it's interesting, Nicole, as we watch these cases, and so much of trial is theater, whether you're there as a juror in the courtroom or one of our viewers or listeners on Sirius XM, the way that this has played out, Charlene Bishop certainly has an interesting role, doesn't she?
Oh, absolutely. You can't watch that testimony without feeling bad for her, feeling like she was such an attentive wife, hearing the prosecution's version of her testimony, and feeling bad that she, too, appears to have been duped by her own ex-husband's character.
Yeah, and she's certainly an innocent in almost every way, knew nothing about the videos, knew nothing about the porn, knew nothing about the computer. Nicole, we know that that was a gun that was used with regard to Rebecca Blash, the murder that Jeffrey Willis has already been convicted of. We know that a shell casing from that gun was found at the crime scene for this particular crime, when Jessica Haringa went missing. That is a little tiny piece of direct evidence that actually links Jeffrey Willis to the disappearance and alleged murder of Jessica Haringa. Do you think that that little piece, with everything else we've heard, is enough to convict?
It certainly could be. I mean, and you said something that was very important to me there, which was with everything else, because
That's right.
They've gotten a whole bunch of sort of character assassination type evidence in here, and now they have sort of the missing link, and they're filling in the gaps. You know, the real question to me is, how far is this judge going to let this particular witness go? The gun itself is highly probative of whether or not he may be responsible in this case for this particular victim's disappearance. On the other hand, some of the other things that this particular witness may say may not have a lot of bearing on whether or not he is guilty or not.
And so many of these witnesses must be awfully motivated to testify and awfully motivated to put yet another nail in Jeffrey Willis's coffin, given the fact that he's such a horrific human being with so many horrific allegations and really terrible things found on his computer, found on his person. And because of all of that, the natural tendency is to sort of, on part of these witnesses, overstate some of the case against Jeffrey Willis. Isn't that something you have to guard against?
Absolutely. I mean, it's pretty clear from all of the folks that have testified so far that these witnesses are dying to tell this jury everything that they know.
That's right.
But the reality is that's not always appropriate in court. We want to keep it to the issues that the jury is trying to decide.
Yeah, it's been an interesting trial thus far. Remember, ladies and gentlemen, this is the second trial against Jeffrey Willis. He has been convicted of the murder of Rebecca Blesh, and now he is on trial for the murder of Jessica Herringa. Her body never found, but lots of other evidence getting in this case, circumstantial evidence that Nicole and I have been discussing. And now we are playing for you some clips of the testimony of a co-worker of the defendant who had a gun that went missing. That gun later tied to Willis and tied to the crimes. Her panties also went missing, consistent with some of the testimony that we've heard about Jeffrey Willis and some of his leanings towards some types of activity that certainly the jurors are not going to like. So let's listen to some more testimony from this co-worker of Jeffrey Willis as we continue to play out some of the key pieces of the case against Jeffrey Willis in the disappearance and murder of Jessica Herringa. Welcome back to the Law and Crime Network. I'm Heather Hansen as we continue to cover the trial of Jeffrey Willis. This is his second trial. He's already been convicted of the murder of Rebecca Blesh. He testified in that case, which I think is awfully interesting as we look at this case and look forward to the defense part of the case. I have with me today Nicole DeBorde. She is a former prosecutor, a current defense attorney, and a fabulous expert on all of these things. What do you think, Nicole? Do you think that Jeffrey Willis takes the stand in his own defense in this case?
Good Lord, I cannot imagine what he could say at this point. The testimony from these witnesses is just devastating. You know, again, I don't really understand how some of this information is coming into evidence in front of this jury via these witnesses, but it is, and I'm not really sure what can be said by the defendant at this point.
Yeah, I was surprised to see him testify in the last case. I think he's probably one of those witnesses who thinks that he knows better than his lawyers, and those witnesses oftentimes end up making their own bed and then lying in it. But I agree with you, in this particular case, it certainly doesn't seem to be a lot. Most of the time when we see defendants testify on their own behalf, it's either insanity cases perhaps, or most often self-defense cases. Don't you think that that's the case?
Absolutely, because oftentimes you cannot get a jury charge or an instruction to the jury on self-defense without testifying. It's not always true, but it's often true. In this case, I don't think that that's a claim, and there's really not a whole lot of good reasons for him to get up on the stand and be subjected to cross-examination on some of these horrific things that these witnesses have said. But you make an excellent point. It's not the lawyer's choice. It's the defendant's choice. And even if his lawyers tell him there is no way you should be taking the stand in this case, he can say, I'm doing it.
Yeah, it's interesting. And a little aside with regard to that last witness's testimony, you know, she works with Jeffrey Willis, or worked with Jeffrey Willis, in a factory. And she testified to the fact that during the time that they worked together, and they were purely work colleagues, they were not friends, he kept asking her for pairs of her underwear. It reminded me of the Me Too movement and how every day things like this continue to happen, and women just seem to not even talk about it, or at least weren't for a very long time.
She has made it crystal clear that she doesn't like this guy. Yeah. She has never liked this guy. If you heard the way she quickly answered that he has never been to her home on social occasions, and the faces that she made while these questions were being asked, she has a very clear disdain for this particular accused, and she made every point of making sure the jury knew that.
Yeah, I'm sure that when he asked her for her underwear, she was repelled. And then when she heard all of these allegations about him, probably not all that surprised. Her body language certainly belied the fact that she was not loving this defendant or any of his conversations that they had with one another. You know, she has provided that piece of evidence with regards to the gun. And we're talking a little bit earlier about direct evidence. So the gun would be some direct evidence in this case. The other piece of direct evidence, Nicole, would be the computer files. And I want to sort of parse that out with you, because in just a minute, we're going to play clips from the computer expert, the forensic expert on computers. But some of the computer files are inflammatory. The videos of the girls at swim meets, lots and lots of videos of pornographic images. But yet there's also evidence in there of a file that is labeled VICS or VIX that included Jessica Heringa in that file. If you're the defense attorney in this case, are you trying to have the judge parse out which of the computer files are allowed in and which of the computer files are not allowed in, or do you just assume that it's all going to get in?
Oh, no, you absolutely want to limit what the prosecution is going to be able to say in this case. And you want to limit it to what is relevant to whether or not your client is guilty in this particular case. So a lot of that other information that you've described is highly inflammatory. Just because a witness is allowed to take the stand or some part of evidence is allowed to come in doesn't mean that all of it can. And a witness and the prosecutor can't just say everything that pops into their head just because a witness has been allowed to testify in a case. Yeah. And so I think the defense has to limit this testimony. Yeah, and we'll see in just a few minutes, ladies and gentlemen, and we'll see and hear that the defense was not super successful in limiting much of this testimony. And it's important to note, as Nicole points out, that it is possible, and in fact it happens in courtrooms every day, where pieces of testimony are allowed and other pieces are not allowed. And in fact, Nicole, that's often a challenge for attorneys, because you have to ask questions around evidence that is not supposed to get in front of the jury. And you have to be very careful not to step on what many of us think of as landmines and do something that is against the judge's order. That can be a very hard thing for a lawyer, right? Absolutely. And when you start getting into a defense that says, you know, my client didn't have a motive to do this, or my client isn't the kind of guy who would do something like this, that really opens the door for the prosecution to bring in a lot of what you're hearing today. So you've got to be very careful, and you got to make sure that you're not doing something that triggers the prosecution being able to get into this evidence. And clearly the judge thinks that something that the defense has done so far has already triggered that, because we're hearing a lot of information that might not ordinarily come in. Yeah, there's a lot. Not only has the door been opened, but there is a brass band getting through that door on the part of the prosecution. And in just a minute, we're going to be hearing some of probably the most damning evidence against Jeffrey Willis, because it is not so much personal opinions or people who have some dislike of Jeffrey Willis, but rather black and white computer file testimony. So in just a minute, we're going to start playing some clips from the computer expert, and Nicole and I will discuss. But before we do that, we want to take you to a quick commercial break. Welcome back to the Law and Crime Network. I'm Heather Hansen. I am here with Nicole DeBorde, and we are covering the trial of Jeffrey Willis. Jeffrey Willis, who is accused of the murder of Jessica Heringa. She is missing. Her body has never been found, but there is, in fact, some evidence tying Jeffrey Willis to this crime. In addition to that evidence, though, Jeffrey Willis has been convicted of the murder of Rebecca Blesh. And so between that allegation, that conviction, the allegations in this case, and the testimony of Madison Nygaard, the young girl who was also abducted by Jeffrey Willis and lived to tell the tale, all of those things together have certainly supported the prosecution in bringing this case against Jeffrey Willis. But Jessica Heringa, her body has been missing, and she had been missing for years before Jeffrey Willis was arrested for this crime. And so this community is certainly invested in seeing that Jeffrey Willis is convicted, and we've seen that that investment may perhaps have allowed some evidence that may have been improper to get in this case. What we're now going to be focused on is the
expert for the prosecution, Gerald McCarthy, and his testimony about the computer files that Jeffrey Willis had on his computer. Nicole, when you have witnesses like this one, you've got experts on, forensic experts, we call them, on computers. Is it difficult to make sure that this type of testimony stays understandable and relatable for a jury?
Absolutely. You know, if you're the prosecution, you want to have met with your expert extensively prior to putting that person on the stand, obviously, to know what is the good and what is the bad here, and to also know what your limitations are. If you're the defense and you know this is coming in, even if you're not going to call your own expert, you need to have had your own expert evaluate the evidence so that you can understand it from every possible angle.
Yeah, and that's a great point, because, you know, a lot of times we assume when we watch a jury trial that we've got a prosecution expert and then you're going to have a defense expert. But that's not always the case. And oftentimes behind the scene, the defense will have hired an expert just simply to help them to cross-examine the prosecution's expert. And
that's exactly right.
It's oftentimes very successful, because then it allows you to really pick apart the prosecution's case and not have to put on evidence, as the defense is not under no obligation to do so.
That's exactly right. You want to make sure that you understand what the prosecution is trying to say and whether or not it's even possible. Sometimes experts will take a little liberty with what they think they can opine about, and you need to know where those limits are.
Yeah, it's a difficult thing for lawyers, because we're not experts on DNA and computers and forensics and psychology, and we do our best, but we really do have to rely upon our experts, because, as Nicole points out, an expert can stretch the truth or stretch the confines of what it is they're talking about within the area of their expertise. And if we lawyers aren't educated enough or informed enough by our own experts, that stretch could get over our heads and we might not be able to catch it. So it's incumbent on the lawyers on both sides to understand as much as possible from each expert that they hire, isn't it?
It absolutely is. Really, the prosecution has an ethical duty. Sometimes they do honor that, and sometimes they don't, to make sure that what their expert is testifying to is something based on science and something that the expert actually knows from investigating the case and can say. And it's the defense's job to make sure that those experts don't go beyond that, and to ask questions about things that maybe aren't quite as solid as the expert would like to paint.
We are now going to listen to one of those experts, and this is Gerald McCarthy. He is the expert for the prosecution in the case against Jeffrey Willis. Jeffrey Willis accused of killing Jessica Haringa. This expert is going to be talking about the files that were found on Jeffrey Willis's computer and what role they had in the prosecution and the investigation of this crime. So let's listen to some of that testimony, and then Nicole and I will be back to discuss. Welcome back to the Law&Crime Network. I'm here with Nicole DeBorde. And Nicole, that was the expert for the prosecution, a criminal expert, speaking about the computer files and the forensics of the computer files. First of all, I want to talk to you just about the straightforward look of that expert. He pretty much is a Hollywood typecasting of what you want from an expert in this type of case, isn't he?
Absolutely. He looks like an investigator. He looks like somebody who's supposed to know about the things that he's talking about. It was interesting to me that right out of the chute, one of the things he said is, oh, this is the largest collection of this type of material that I've ever seen. That's the kind of thing that shouldn't happen. That has nothing to do with this case. You know, sort of the nasty nature of the things that were searched and saved speak for themselves in this case. We don't need his extra sort of opinion about whether or not this is the most he's ever seen or it's a small amount. He's not that kind of expert.
Yeah, and you make a very good point. I mean, these types of things, while the audience may have no problem with all of this getting in, these types of things are not supposed to get in our system, because these types of things are irrelevant. Everyone who watches Law and Crime, everyone who watches any of the TV shows about the law, they know that relevance is one of the main weighing factors that a judge has to decide as to whether or not it gets in. And for this witness to say that this is the largest amount that I've ever seen, what's the relevance, Nicole? What possible relevance could there be?
It has none. It is relevant, I suppose, to making the jury mad. It is not relevant to whether or not this defendant committed this crime. So it's certainly doing what it was designed to do, and that is to upset the jury. And that's kind of what trials are about from one side or the other. You want them to believe in your side, but a judge has to do a good job of, and the defense has to object. The judge has to keep that kind of evidence out.
Yeah, and this is important not just because it's the way that our system is supposed to work, but it's also important because if there is a conviction in this case, the defense is going to have a lot of argument on an appeal in this case. Don't you think? And then I want to kind of follow up with that. But don't you think they have a lot of strong appellate arguments?
I think they do, and I think that they're obviously much stronger when the trial lawyer is making objections to evidence that shouldn't be coming in.
That was going to be my next point. Go ahead.
Well, and the reality is that, you know, their homework is going to be checked by some other lawyer in the future. And generally speaking, you know, trial lawyer may do his own appeal, but he might not. And in some states, you're able to get into error that wasn't objected to, and others you can't. Now, that is something that could be attacked later in a post-conviction writ, which is a fancy way of saying another lawyer can check the appellate lawyer's homework and also the trial lawyer's homework. So these guys need to be able to explain why they're not objecting to some of these weird sort of attenuated opinions coming from these so-called experts. This is a computer science expert, not a psychologist and not a psychiatrist. His testimony really ought to be limited to what he knows about.
Yeah, ladies and gentlemen, if you are ever in a position where you need a defense attorney, Nicole is the woman, because she's absolutely right. And it's important to note for all of you watching and listening that unless an attorney objects, there's an argument to be made that you can't appeal on an issue unless the attorney has raised it at trial, because you have waived the argument. You have given up your right to that argument. So the fact that the defense is not objecting to some of these things may put the defense in a difficult position when it comes time for an appeal. So Nicole's point is very well taken. And as you listen and watch this testimony in this case as it continues, pay attention to that, because even if everyone out there wants Jeffrey Willis to be convicted, that conviction may not stand if there is enough of an appellate issue to overturn a conviction. So let's go back and listen to some more of the testimony of this computer expert and paying attention to those types of things and how they may play out, not just in the case that we're now watching, but in an appellate process as well. We'll be right back. We're going to watch some more of this testimony. Welcome back to the Law and Crime Network. I'm here with Nicole DeBorde. And Nicole, we just saw the defense for Jeffrey Willis actually stand up and object. What did you think of that objection?
I was so happy. I was so happy to see him object. It warms my heart. The reality is that we need to have confidence in these verdicts, and letting the prosecutor and this expert just go running, roughshod over every topic that pops into their minds is not a good way to make sure you have the right answer. And so seeing him object, I think, is a positive thing. A lot of the matter-of-fact testimony that this particular expert was testifying to just now is appropriate. He's saying, I went into the computer, I found these files. That's what he's there to do. Now, getting into testimony about, judgment-type issues about those files is not his job. And so he also needs to make sure, this expert does, that he's answering the question that he's asked. One of the reasons that's important is a lawyer needs to be able to understand what evidence is likely to flow from the question so that they can prepare for an objection. And so that's what the lawyer in this case was objecting to. This guy's just answering all kinds of questions that weren't asked, and I object to him going on and into a narrative. I can't prepare to object to evidence that shouldn't be coming in if I don't know what's coming.
That's right. That's right. If you don't know the question, you don't know the answer, and therefore it makes it difficult to object. What you often have to do is move to strike, and once the evidence has been heard by the jury, it makes it very difficult. The other important thing for our serious listeners to know is that during that testimony, the jury was seeing pictures of some of the materials found in Jeffrey Willis's possession, one of which was a ball gag. We heard testimony about the ball gag. There were handcuffs, there was rope, there were syringes, which Nicole and I have already talked about, that have been testified to. There were guns. This type of thing, knowing that this man had these types of materials in his possession, certainly isn't going to predispose a jury to feel all kinds of warm and fuzzy about him, is it, Nicole?
Oh, absolutely not. And, you know, obviously it is what it is. I mean, this physical evidence was found in the defendant's possession. The prosecution is allowed to get into it. This is upsetting enough. I think most people would agree. I really don't know that, you know, having witnesses testify to things that aren't relevant was necessary, and it's potentially dangerous for the prosecution. It puts the verdict at risk.
Yeah, it is, and that's a very good point. A lot of this is unnecessary. You know, you've got to be willing to let the evidence stand on its own, especially in a case where this defendant has already been convicted. I've seen if the local papers have been following this case, and some of the local residents are wondering why the money has been spent to retry this case. And if you are having those types of concerns, knowing that there's also going to be an appeal would also be concerning. So it's in everyone's best interest to really limit the case to the evidence that is fair and probative and relevant against Jeffrey Willis.
I agree. I agree. I mean, the courts are very, very busy. You know, you have 52 weeks in a year. 50 of those weeks are available for trial because there are holidays and other things that come in between a jury and the courtroom. And you have to make a choice about all of the hundreds of people that are scheduled for their day in court in a particular court. Who gets that resource? And it costs a lot of money to try a case like this for the prosecution and for law enforcement. So they have to make a good decision about whether or not it's a worthwhile effort to use those resources. Once they've committed to using those resources, they better do it right.
And one of those resources is the expert. So let's go back and continue to watch and listen to this computer expert as we continue to follow this case against Jeffrey Willis.
Crime.
Welcome back to the Law and Crime Network. I'm Heather Hansen, and we continue to cover the murder trial of Jeffrey Willis. Jeffrey Willis is accused of killing Jessica Haringa. Her body never found. However, there are some pieces of evidence that link Jeffrey Willis to her disappearance, and Nicole DeBorde has been with me, giving us the insight that she has from being on both sides of these types of cases over her days as a lawyer, now a criminal defense lawyer. Nicole, thank you so much for being with us here today.
Thanks for having me.
Listen, we're still watching and listening to the testimony of the computer expert. And before we took those breaks, there was a piece of evidence with regard to the folders in Jeffrey Willis's computer that were specifically labeled with Jessica Haringa's name. Now we've talked a lot about evidence that might not get in or might not be important or maybe shouldn't be admitted. This is very important evidence, isn't it?
Absolutely. This is the direct evidence that the prosecution needed to get to. And this is the kind of thing that a jury can use to hang a conviction on, or to hang their hat on is a more correct way to say that.
Yeah, and it's certainly strong evidence. I mean, there's no reason for Jeffrey Willis to have a file with Jessica Haringa's name on it at all, much less with under the heading of VICS and included with other of his alleged victims. Is there any way for the defense to explain away this testimony?
It doesn't seem to me that there's going to be any easy way for them to do it. I can't think of any way to do it. And the reality is that this expert was called specifically for this purpose, to get this information in. He talks about what's necessary to save information about a particular website. We know it wasn't an accident based on this expert's testimony that her information was saved on this computer. We know that this defendant had a folder marked with VIX, which we can all take to mean victims, with this particular person's name and information saved in it.
Yeah, when you're preparing for a case, Nicole, you know, how important is it to be going through these computer files with a fine-tooth comb? I find more and more, both in the cases that we cover here and the cases that I have in my own practice, that the computer evidence, and not just the overt computer evidence like the emails, but those files hidden behind files, and the metadata, and all this stuff that is very frankly often over my head, it becomes enormously important when you're trying to make or defend a case, doesn't it?
Absolutely. It's important to understand why law enforcement thinks that this folder was there and how they got to that information. How did they get into the computer in the first place? Did they have the right to be there? And did they use the information they found properly? And did they evaluate it properly? And these are the kinds of things that you almost always need an expert to help you with.
And we've spoken about that a little bit. Do you expect in this case, given the evidence that we've seen thus far, do you expect in this case that we will hear from a computer expert when we hear from the defense part of the case?
That's an interesting question. The defense hasn't really raised, any objection to this testimony coming in. It doesn't sound like they really have issue with what this particular expert is saying. So I kind of doubt that we'll hear from someone saying something different on the defense side.
Yeah, it's going to be a challenge for them to put someone up to say anything that is of any real importance here, given the fact that, as you said, there's not a lot to be done with the idea that you have this folder that is labeled VIX that has these references to this victim in this case. There's no good way to overcome that piece of evidence. Now, in your closing, Nicole, what do you do with that? Do you try to establish that it's not enough to meet the prosecution's burden of proof, or do you try to counter it in some way?
I think that's the only thing this defense team can do is say, look, it doesn't look good and her information is in there, but we still don't have a body and we still don't have evidence that any crime ever occurred.
Yeah, it is, as you said, it's a very difficult thing. The missing body, normally, I think we would oftentimes say, well, that is really going to be helpful to the defense. But with so many other pieces of really upsetting testimony, it's going to be really hard for the defense to overcome. Now, I know in just a few minutes we're going to lose you, Nicole, because you've got to go back to your practice for this afternoon. Before we do that, I want to talk to you about what we should be anticipating from the defense in this case. We still have to hear from the prosecution the rest of their case, but what do you expect the defense will do to try to make a claim as they counter it?
I think the cross-examination of each of these witnesses is the critical step for this defense team. They really are not in a great position to be calling any witnesses from any of the information that I've seen so far. To me, the only potential avenues of attack based on what I've seen so far are tough cross-examination about how reliable the information this jury is hearing is. And then later, the defense can tie it up in closing argument with the ideas that we've been talking about, which are that, really we have a lot of inflammatory evidence, right, but nothing directly indicating that a crime occurred.
Nicole, thank you so much for being with us today. We're going to go to a break and we'll see you later.
Great. Thank